Hello, my name is Lidia Blaszka. I am an attorney at law and partner at BLS Legal Office. In my professional practice, I focus on real estate law, including planning and zoning. Today, I'm going to talk to you about an important aspect which needs to be taken into consideration when making a real estate investment. How the real estate can be developed in accordance with Polish law and what conditions need to be met in order to carry out a real estate investment. So, in Poland, it is possible to develop real property on the basis of a decision on land development conditions or a zoning plan. Therefore, before you decide to invest in the real property, you need to check whether the decision on development condition for the plot of land has been issued or whether there is a zoning plan in force. Only on that basis can you get a building permit and use permit. Today, I will point out the basis conditions that must be met in order to obtain a decision on development conditions. In another video, I will talk about the documentation that must be submitted when you are trying to obtain a decision on development conditions. According to Article 59 of the Act on Planning and Spatial Development, a change in land development in the absence of a local zoning plan involving construction as well as change of the way a structure is used requires a decision on the land development conditions. The decisions on the land development conditions are issued by the mayor of the municipality, so the application should be submitted to the municipal office. When issuing a land development decision, the investor must meet the following criteria in particular. First, at least one neighboring plot accessible from a public road is developed in a way that allows the requirements for new development to be determined. These requirements consider the continuation of the function, parameters, features, and indicators of development and land use, including the size and architectural form of buildings, building line, and density of land use. This is the so-called principle of the good neighborhood. Its goal is to take care of the spatial order so that it creates a harmonious whole. It is often the basis for controversy between the developer and the authority, since the assessment determines whether a given project is a continuation of the functions, features, and purposes of the plot might be judged differently. The principle of the good neighborhood applies only to new construction and also to reconstruction and extension. Another condition to be fulfilled is the plot's access to a public road. It might be direct or indirect by establishing an easement. The third condition relates to the sufficiency of existing or designed utilities of the land for the construction project. What is this about? Utilities are devices necessary for the functioning of the building in accordance with its use or purpose. This is assessed separately each time depending on the project. This assessment requires reference to professional knowledge. Any statement that the utilities are insufficient should be justified in the refusal decision. It is not a matter of making the land development decision conditional on the current state of the utilities, but rather a guarantee that adequate infrastructure will be built to enable proper use of the buildings. An additional condition to be checked when issuing a decision on development condition is whether or not the area requires consent to change the purpose of agricultural and forest land for non-agricultural and non-forest purposes. That is all for today. In another video, I will present to you what documents should be submitted to the office when obtaining a decision on outline planning and spatial development. I know, but I have glue in my eyes. Today, okay, maybe from the beginning. Okay, but thank you. I know, and thank you that you are.